And I keep coming back to the problem that as you get better and better tools to do something, that people naturally get lazy about thinking about things more robustly. And from an educator's point of view, it becomes very difficult because you want people to expand their knowledge base and to incorporate that as part of what they're doing. And that's true of lawyers in general.
And I'm gonna use an example here and jump in. I don't know any phone numbers anymore by heart. My phone keeps track of all of that for me. And you're right, it's intellectually lazy. I still remember both my grandparents' number, my home phone number when I was a kid, and all of those other numbers that I had to memorize. But phone numbers go away after I was about 24 or 25.
Well, and it's funny because I found in my research class that essentially the ability of students to do research in my class has gone down over time. And I attribute that entirely to Google because, and the reason, and Google-like things, and the reason why I say that is because that people no longer want to memorize things. They always know that they can look on Google and look up the answer. And by doing that, they limit what's available in their memory. And that makes it very difficult for them to sort of think outside of the box because their experience becomes very narrow. And I think that AI has the potential to make that even worse. Because as you're able to push off more and more of these tasks and outsource them to AI, that the thinking process gets clumsier. And so it makes it much more difficult, I think, for people to be able to do the tasks that people need to do.
One of my responses to your criticism of AI and AI analysis of law is that AI wasn't created to analyze law. And it does a very poor job at it because it's a large language model and all it's really doing is predicting what the next word should be. So as I think about that and my response to you, it would be, well, you need a lawyer to write the prompt. You need a legal engineer to prompt write. You need a lawyer to assess the response. And I think what I'm hearing you say is we're losing our ability to assess the response, perhaps.
Well, absolutely. And, putting on my economist hat for a second, I mean, it becomes less and less viable to hire people to do that if they think they can do it without having to pay for it.
Other input?
I think Massimo is probably closest in terms of what we're going to have. There's going to be multiple plugins for Word or Outlook or whatever, like you were talking about at lunch, that make my life easier. In writing a brief, starting the brief, typing in a small prompt and spitting out a whole bunch of stuff that I can think about, something like that. And then I do worry about that. That feels very old manish, very get off my lawn-ish. You're right, and I had the same thing thrown at me when I was 22, and I was using Google and whatever stuff to do things when I was in my comp sci program. Right, it's like you don't know how to do that, or you don't know how to use West's notes because you're typing in a Westlaw. That was right as my transition when I became a lawyer. You don't know how to use the real book that I had to learn to use the book first semester, then we threw them away, and I never looked at them again. Right, so you're right, and I wonder if it doesn't hinder logical development or whatever. There's sort of like lots of human type tasks that we should be doing, but it may just be kind of lost. It's kind of like we may just lose them.
Well, there's that cynicism that's possibly there. I mean, strangely enough, I'm both the modernist in the court and also somebody who relishes the past. I love history and things about that. But I do find, though, that although there's this tremendous resistance towards moving forward, which makes it really tough to use these tools like in my job because we've got good cutting edge new 1990s technology. But that it's the sort of thing that as people become used to using that, they'll have to. But then they'll use it and they'll just stop there because it's the quickest thing to do, and unless it's incentivized to do more than that, people don't do that.
Will anybody even know they're wrong because the other side's not going to be doing anything more than that either?
And that's and then the weird thing about it is that's happening right now because I was talking about it at lunch. That what I find as a typical problem with lawyers is that when lawyer A makes a motion and says X, that rather than challenge whether X is correct or not, they don't bother to look it up. They assume that is correct, and then they argue based upon X being the rule. Countless times I've encountered that X is not the rule. In fact, it may be that the exception to X that's in the same case that they cite is the facts. And that that sounds silly, but it's actually an exact example of something that is I've seen in my court, and it's a problem because of, I use the pejorative term laziness, but really it's a matter of prioritizing what you can do, and you've got to stop someplace, and people stop awfully early in that process, and I don't think that's changing, and I do think that's where AI offers both the opportunity to have something more, because the AI can do more work, and that would be a good thing. But it also means that the lawyers are doing less work, and they're doing less thinking work.
Yeah.
So that's why I'm cautious.
And
about
if AI doesn't do analysis, the lawyers should be doing analysis, and if they're not, we have a problem.
Absolutely.
I have a response to the cynicism. I agree with everything you're saying.
Young man. Okay.
But this is kind of taken from.
Wait till you get into the real.
Yeah, wait till you're old like
I know.
us. I
I'm
don't
in
know.
fairy tale land. But the there's kind of like a historical. You can kind of look at history for like Industrial Revolution, all of these sort of technological changes, and certain jobs. It's kind of an analogy with jobs, but as you're saying with skills and laziness, certain things just disappear. Skills are lost. But then there's usually in net an increase, and there's sort of like new tasks, and maybe maybe that'll happen with law, maybe it won't, maybe we'll lose skills and lose jobs, but or maybe in total in net certain things will go up while other things go down, like legal research. But as for new skills, there might just be skills that we're not really able to contemplate right now that lawyers will have to learn. Like instead of maybe just assessing, maybe every lawyer, this has been proposed 20 years from now, will have to basically minor in data science and know how to like assess the AI tools they're using once they get good enough to be, used to that extent. So I don't know. It's just sort of and maybe there will be new tasks, AI-related lawyerly tasks, and so the whole skill set will just change. We'll just get worse at research, like you're saying, but we'll get better at other things that are now necessary.
Well, one of the things I think that indicates, though, is that it really implicates the ethical obligations of lawyers, because lawyers have obligations to be competent. They have obligations of duties of candor to a court. They have obligations of supervision. And in order to do all of those things within the standards as we think of them today, that it really does involve the lawyers participating in the process at a level that they're not going to be very comfortable with. And so certainly part of the process of developing AI and using AI in the legal industry is also going to mean being able to understand how to ethically use those, so that you're not just pretending, like in my paper, if you think of that's the right answer, then you're going to be stuck like the guy who was sanctioned, because he mistook it for being correct, and that was stupid for him to do something like that.
Or the other pejorative term, lazy.
Yes. But he was actually stupid, though, I would say, simply because he doubled. And the reason why I'd say that is because it's lazy to do it in the first instance, but then he doubled down when he was caught and said, he asked ChatGPT, are these real?
And to provide the text.
Yes.
Yeah.
And so rather than checking it out himself, he let ChatGPT tell him. And what happens when you ask a liar, if they're a liar, they say that they're telling the truth, and
So this is a great segue into the next question. The adoption of AI in legal practice raises concerns about the standards of care in the profession. How should lawyers balance efficiency and insight that AI can provide with their professional responsibilities? And maybe more importantly, what safeguards should we put in place, and how do we put them in place? And I'm gonna use a sort of an example here. We have the lawyer you cited down from Texas, or the judge from Texas, who's making people sign off and say, I used AI or I didn't use AI in this brief, and here's how I used it, right? AI is getting added to all of these different applications we use. It's in Word, it's in Grammarly, it's in all of these things that are common. How do we go about identifying everywhere we use AI, and what about our duty of candor to the court in these circumstances? We don't know what we don't know, right? It's that Rumsfeldian unknown problem, So we're in that place. So what's a lawyer to do?
I think Massimo's point about data science, I think maybe it's a step too far in my view, but you're right. I think it's like when I was coming up, search engines were novel, and like any kind of programming software was novel, and like that's different than now. Like you don't know how Google works. I mean, maybe you know, but the average user doesn't care. It just works, right? Like, but I sort of vaguely knew how it worked when I did it. So I think AI is going to be like that. And I think your point, that goes to your point, which is your question, which is, it's not going to matter. Like at some point, it's on you, but it is really just another tool, and your candor of duty remains the same. All those sort of things remain the same. It's just you are now using another layer of tools, and you're still responsible for all the things Word typed in or whatever, or that you typed in previously, right? Or the search results from Westlaw. Like, how do you know that those are correct? You found that case, it's in there, someone reported it, but you don't know anything.
And the herd trusts Westlaw, so if the herd trusts Westlaw, it must be good.
That's, I think, where we'll get there, exactly, we'll get there with AI. It'll just be like, well, this is what it told. How do we get solipsism if you want? Like, I'm in my own head and there's nothing existing in the world. How do I know any of this is real? Descartes or something. but it's like, it's kind of like that, it feels like to me. At some point, it just is what it is.
It's all a simulation, so it really doesn't matter.
Yeah, who cares? All my cases are real in my head. I don't know.
I think there's an analogy between this and the computer-aided review from Discovery. It used to be a human had to look at every single document, and then the past 10 years.
It was Judge Peck. He said basically, yeah, you're committing malpractice if you don't use TAR.
Yeah. And so the computer would predict what documents were relevant and what weren't based on a seed set. And so right now, a similar thing with the writing, the human has to go through and verify every case, verify every argument, and as it gets better, we might get to a point where you must, that review won't be necessary, or perhaps you must use it.
Yeah, and some of those discovery tools are pretty advanced. You feed it all of the discovery, and it comes back with the arguments that you should put in your and the complaint and how you should file based on the information.
Didn't we find a state bar that had a rule like this, or is that one that we found someone proposing? There was an AI related rule for lawyers. I thought
the state of California is asking for your feedback on AI right now and what your obligation and duty should be. So I would ask each of you to ponder that and actually write something to the state bar before they tell you what your duty should be.
Well, I will say that it probably can't be the case for an individual judge or an individual court to make those kinds of obligations separate and apart from something that comes to the state. Particularly
That's not going to stop the judge.
Those are known for restraint,
I can only speak for the judges of my court. I wouldn't likely that's going to happen.
No.
And there's a rule in the state California rules of court that preclude individual courts from having local rules that are going to affect formatting and things like that. So there's institutional reasons why that wouldn't happen at a local level. Federal courts are different, of course. They're all doing their own thing.
They're all
They're a
doing
fiefdom
things.
unto themselves, but there is a problem that as it develops over time, and that is an issue. Like you were saying, it's like, well, if you start with a rule that says you've got to disclose, but then things are going to develop a lot faster than the rules process, which is painstakingly slow.
So I noticed you all dodged the guardrails question.
Yeah.
Does it need guardrails? How do we put guardrails on
I
this?
think you're the guardrail. I mean, theoretically,
It's
for
a
now.
runaway.
For now.
It's a runaway train.
It's a trolley.
God save us from the trolley.
We're on the tracks.
It was a lifeboat when I was taking ethics, and they wanted to know who you throw over because it only supports so many people.
Mm-hmm.
But similar thing, right? So what do we do with AI? How do we put what do guardrails look like?
So I can't speak as a lawyer, obviously, but the alignment problem is what computer scientists call it, and that's the idea that you basically make sure that design is centered around your goals. And in law, that would be our legal traditions, our actual laws, what we want. And some AI researchers think that we are 30 years behind on that, and that it's literally too late to catch up because there's absolutely safety is not in mind. It's just function, and there's all this capitalist pressures to beat out other companies or other countries. So guardrails would look like, don't build the thing until you have rules and ethics thought out. Air gap it. Don't have it online. ChatGPT was trained on the internet with just the whole thing, right? That's not probably very safe, but
How do you know that's so? I read it on the internet, right? I
Yeah.
mean, and so your legal advisor read it on the internet? That doesn't sound very good.
Yeah.
It strikes me to be more of a problem in the transactional world than in the litigation world. The adversary system is built in to have it so that somebody has a strong incentive to demonstrate that something's wrong, would do that. Not that they do that all the time, but nonetheless, they at least have an incentive, and the system depends in a certain sense on that. And then there's punishment, there's sanctions, there's simple sorts of things like you lose your case, or you lose
Motion.
or you lose the respect of the court so that your credibility drops. You have the potential for discipline for violating your ethical rules. All those things exist in the court system.
Personal reputational impacts.
But those things don't really exist in the transactional world because it's very, very difficult for people who are not lawyers in particular to be able to assess what the impact of this is going to be on different people. Now, the lawyer in New York who got sanctioned and got national attention for doing a stupid thing, that person will suffer. But that's probably the only person who's going to really find themselves suffering because of the attention that is there. So it seems to me that in keeping it merely in the context of the legal community, that guardrails would need to be there in terms of how it is that lawyers interact with one another. Because we're the only people, I think, who really are in a position to be able to assess what other lawyers are doing.
Maybe stories like the New York story, though, are a deterrent if we're talking about criminal law, kind of, in a sense.
Right.
You hear that, and that's like, dear Lord, I'm never doing that because I don't want to be made fun of across the entire internet. You got the guy who had the cat face
the guy with
during,
the cat
during his appearance. Like, I'm never putting a filter on my Zoom call. Like,
Ever.
ever.
Yeah.
Letting my children ever touch this thing. Anyway, yeah.
Yeah, exactly.
So I kind of agree. I think the guardrails are you, and the guardrails are the courts themselves, and something like that. You're right.
Another guardrail is just open versus closed source debate, right?
Sure.
Just closed source it and don't give it to people who aren't competent to use it and know exactly how it works and sort of like self-regulate. There was a large language model was leaked, Facebook's, and now that's kind of a weird thing where people are like messing with it and who knows what's going to happen next. So that's just a classic debate of open or closed source,
At some level, it's just credibility too, like you were sort of alluding to. If Lexus is offering a tool, sometimes they're a little kludgy, or West or whatever, it's probably okay. That's horrible to say, but it's probably okay because they're going to lose a lot of face if it's not.
Right.
So it sounds like reputation across the
Reputational
board.
matters.
It may not be a thing where you should go with a startup, right?
Maybe, right, exactly, right, and that's what's weird. There's a million startup tools, right? I get emails every other day. We were talking about it. It's like, I don't know if any of these are. I have no idea. How would I know?
Right.
I don't really want to spend the time to figure it out.
Well, if you invest in one, clearly
I'll
that
let
can
you know.
clearly that can be a bad thing, right? And you
Well,
end
yeah.
up,
Yeah, that too. Yes, I've invested in 4. No, I haven't.
So maybe what I'm hearing collectively is leave the rules as they are and interpret AI and the use of AI within the standing rules. We don't make any changes.
I think the bar is going to do something which is going to be weird or unfortunate when I feel like their existing rules probably are pretty good.
Existing rules.
You know,
fit
like,
into these systems of competence and
Candor and all the
standard
things.
care.
What you'll see are opinions from either the state bar formally or local bar associations informally about things that you should do or shouldn't do that would provide guidance to the community as to what would be considered to be below the standard of care and above.
And we saw this with discovery, right? We coined this phrase e-discovery for this new world of discovery, which was just old discovery implying the rules, right? So we made up new rules and we added some electronic media, some ESI, and then it was supposedly all better. And there's still things that we're trying to come to terms with. And maybe it needs a change in the rules, maybe it doesn't. So yeah, my jury's out. I'm not sure if we have enough in the rules of professional responsibility to cope with a whole new intelligence that is basically competing with lawyers and lawyers are using it, that isn't governed by our rules.
Definitely welcome letters or like opinions. Like,
Yeah.
There's one in email, there's one in document storage, there's all these different ones, I've definitely welcomed that, as opposed to a whole new slew of rules. Like
Well, also.
Letters would be nice.
Like, yeah, exactly.
Oh, so there's some analogy here that I can use to impact my behavior.
And that's something that could be handled now, because people can request, informal opinions from bar associations that have, a lot of persuasiveness in terms of their opinions. But in terms of actual formal rules, the process is very slow. And it's always going to come, long after there's actually a problem. And until you actually see that there is a problem, you're not going to see a rule that's addressing that problem. So there's a multi-year, perhaps even multi-decade gap.
Technology is moving so fast. One of the things I was part of Stanford's Future Law conference in April this year. And these are people who are working at the heart of AI and AI's impact on the legal system. And they were saying that 6 months ago, they would have said that ChatGPT and what it can do is 10 years off, right? And these are the people at the heart of doing this and creating these new technologies. So if they're caught unaware, how can the courts be responsive in that circumstance? I mean, these are the people that are creating the tech, and they're blown away by the advances that have happened with.
But some of the things that you're going to see, what you haven't seen yet really is going to be actual litigation over the professional breach of responsibility. Somebody saying a lawyer committed malpractice by doing X, and X involved using AI in some way.
That is the grounds.
The Fugees, but
That is the grounds for the appeal in the federal case.
It's that's not something where you've got a body of law that you can rely upon.
Professor, I have a question for you. Do you think that could AI be so ubiquitous in a little area of law where there's no formal rule, and you think that could fall below the standard of care? Like a judge might find that, well, you've fallen below minimum competency by not understanding AI in this area without some formal
So
rule.
turn it on its head.
Well, just hypothetically, the first thing is it wouldn't be the judge who'd be deciding that. It would be a jury. And a jury is going to be deciding it based upon a panel of local lay people from lots of different backgrounds who are making that decision. And they're going to listen to a lot of evidence from people saying, well, I do this, and that could go anywhere, right? Honestly, because the thing is that the jury's expertise in this is going to be limited, and their ability to assess that is going to be somewhat limited. So it creates a lot of uncertainty, and uncertainty is always bad transactionally. It costs money for people to take steps to protect themselves against the hazards that are created by the uncertainty, which is why it would be great to have something out there that gives guidance, but guidance only, so that the technology can continue to develop without having to have it being
restrained
or pigeonholed in a way that lawyers are not going to say, I can't do this because as soon as I step outside that box, I'm suddenly going to be exposing myself to all kinds of malpractice liability.
So I'm going to change gears a little bit here. AI systems often operate as a black box, making it difficult to understand how they arrived at certain conclusions, what data they used, what the algorithm was. How significant is the issue of transparency and understanding the technical aspects of AI in the context of using it for legal purposes? Should lawyers have to understand what they're using? And then, what steps should legal practitioners take to ensure that the AI decision-making is transparent, unbiased, and accountable? So what do we do? We don't know what's in the black box. We're going to use whatever that black box feeds us. And are we holding the black box accountable? And who is accountable? Bob brought up this whole autonomous vehicle and liability and responsibility for those actions. Who's responsible?
In the context, Bob probably knows, but in the context of AI vehicles, it's been presumed that the manufacturer will be responsible, which is funny because that's why they're all claiming level 2 now, as he pointed out, as opposed to level 4 or 5, because they don't want to be responsible. So in that context, then it's back to my GitHub Microsoft thing. It's Microsoft's responsibility. It's the person who makes the tool. It's not necessarily mine if we don't know what's in the box, in my opinion.
Okay.
My malpractice insurance is now Lexus, I guess, I don't know.
Well, the Wisconsin Supreme Court, I think it was, said it's fine, at least in the case of informing a judge's decision, so long as it's only a small sliver in this larger analysis and we understand what the output means. They said that the proprietary enigma was not a problem with like procedural due process or anything. But that was just, Wisconsin Supreme Court, so we'll wait for,
So much for civil rights, right?
Well, it was more complex than that, but yeah, I mean, it was, some people were not happy with that.
But one of the problems that I see, is accountability to whom and how. When you look at judges making decisions, judges can make decisions in lots of different ways. One problem, we were having an interesting discussion at lunch about, there's a political side to that, because if you have an AI program that is saying set somebody free, don't keep them in prison too long, or let them out, don't let them out on bail. If the judge is going to vary from that, that's going to set a bar against which people are going to measure the judge's conduct. If the judge is getting it wrong, the judge is taking a risk. And the risk that the judge is taking by disagreeing in some way with the AI program, provides a level of incentive for the judge not to do that, because it avoids the potential for responsibility and negative consequences to the judge personally.
There's some irony in that the very risk consciousness of lawyers that stops us from using AI in the first place is going to save us from AI.
Well, but it won't though, because the problem is that, as was mentioned, and I'm sure it'll come up again, is that these things do have inherent biases. Whether we like the biases or not, the biases may reflect societal norms or they may not. But they are all probabilistic, and it's all a Bayesian process in which that you are trying to update nodes and weights throughout the neural network. And the process of doing that is going to be by using whatever information is coming into it. And if you don't have the information about the mechanism by which it's making its decisions, that you are going to be disguising all of this, into the output, and then you're going to be giving it this cloak of respectability. And so if there really is some provable bias, because there is a correlation between the nature of the people who are arrested, regardless of whether or not they are also, that correlates highly with the nature of people.
Correlation does not equal causation.
Yeah, exactly.
Yeah.
And so that you can have this problem that you're going to be introducing this bias that you can't effectively combat in an argument, because first of all, lawyers don't understand enough about this to be able to articulate it in general. And secondly, that even if they can, that there's this huge risk that's going to exist on the part of the judge in buying that answer, because it puts the judge at risk of retention election or something.
So
like
let me ask the question: our rules hold us to a certain level of technical competency. What is that? And does it apply to this? And what is enough technical competency in this new world we face?
I'll let somebody else answer. I'm talking all the time.
Again, I'm a comp sci major. I was a huge nerd. I feel like technology is passing me by finally, maybe at this point, which is fine. But the point is, I think there are many attorneys who are more successful than me that have no idea how email works, or how Word works, or how Google search works.
Absolutely, it's a tool.
It's a tool, and then they just use it, and then whatever. Right. And I knew how it worked, and knew how all these things worked for a long time, and I don't know that it really mattered in
and
my
to
practice.
be fair, the earlier generation of lawyers didn't know how IBM selective worked.
Or typewriters worked, or yeah.
Exactly.
There's really it's just been this progression from bugginess.
I drive
right?
my car. I don't fix my car, kind of.
Right. So yes, I think you have to have some competency to be capable of combating an argument made by an attorney who's very, very fluent in it against your client, for example, or writing an agreement, whatever. But I don't know that it requires you to know how it works. I guess, or no.
Third-party expertise is useful in
Probably
this.
sufficient, right?
Yeah.
Probably.
Yeah.
Error detection, right? I mean, if you drive your car off the road, do you know if you've cited something incorrectly from your artificial intelligence, or that it didn't do its due diligence, or it has this bias that it overlooks this class of cases, things, whatever. So your competence is not in necessarily, you have to be able to use it, but also to detect and predict errors and guard against those.
We used to call that a BS meter.
Yeah, or like you can
Yeah.
hear your car clunking. Like, oh, there's something.
Oh, there's something
doing
wrong
something
here.
weird.
This doesn't seem right.
I wonder about the biases thing too. Like, humans are biased. Like, period. Like,
And if a computer is learning from
humans, it's like I
Only
think
as we are.
I think it's impossible. I mean, we always strive to better, all those sort of things, right? But I think it will always be present, and so we have to be aware of it, I guess, or like
Well,
error
test for
detect it. You know, like
So those be, you know, how much bias is
acceptable. Like, I don't,
Yeah.
like none. But
Which
like,
is,
how do you get to none?
which is literally a statistical test.
right.
It all comes back to statistics, right? On some level, yeah.
Mhm.
Anyway.
Great, so I'm gonna change gears again. Access to justice is a fundamental principle of the legal system. Is AI going to help this or hurt it? And how can we balance access to justice with all of the potential ethical concerns of having people proceed to chat GPT pro se?
So this is kind of an economics question that is not answered yet, but we know that like everyone is saying, well, ChatGPT is going to sort of democratize something and sort of help the boutique firms, but then now you have APIs and certain large firms are training ChatGPT just their contracts and only they have access to basically a mini ChatGPT. Boutique person can't compete. They're not this giant firm. They don't have the money, the expertise, or the time, or any of that pool of data of all those documents to do this. So in that sense, it's not promoting, democratizing AI across the legal field. But on the flip side, there are so many different competing companies and different programs. Like you were saying, GPT-4 is $20. So there's this huge argument on the other side that like, yeah, if these tools are helpful to the practice of law, then yeah, it's definitely increasing access to justice. And then there's sort of the ChatGPT becoming the WebMD of law problem. I don't know if that counts as access to justice because that's, potentially horrible.
Anecdotally, we're already seeing people that are winning their parking ticket disputes
Yeah.
and doing other small scale. So we're already seeing at the very low level that it is improving the access to justice. Whether or not it's getting good results, we'll see.
Well, the question is, right, is ChatGPT better than no lawyer? And that's really, because 80% of people in the United States never see a lawyer in their lifetime.
Mhm.
So what about those people?
Yeah, if you're lucky. If you
Spin the wheel of misfortune?
Yeah, well, if you can't afford an attorney and you need to write a letter to an administrative agency, or there are certain things it's trained on. I've run comparisons myself of I'll ask Google, how do I do this? How do I write this letter to the Social Security Administration? I ask ChatGPT. Google gives you the address and it gives you the phone number and it tells you here are the factors to be considered. ChatGPT writes the letter for you. So in that sense, at the very low level, I think it's going to improve access to justice.
And certainly to your point, I've heard about people writing letters to landlords that were trying to evict them or raise the rent that are very persuasive, that they're self-advocacy at a point that doesn't quite reach legal, but at least it's personal advocacy.
And is better than they would have
And
done.
better than nothing.
And maybe forestalls, a result that would occur if they didn't have access to it or
And
some
the
expensive
folks I
litigation.
know at LegalZoom wouldn't appreciate hearing me say this, but I gotta tell you, ChatGPT can come up with some stuff that's better than what LegalZoom spits back out, so.
Well, it should be the case sooner rather than later. That you will see AI, whether it's ChatGPT or some other
Some tool.
some AI tool, being able to actually I think having a tremendous impact in terms of self-represented litigants, primarily in like the family law world. That one of the consequences of lawyers being so expensive is that the enormous number of people go through the family law system without a lawyer because they simply can't afford it.
Right.
And that's one area where the absence of lawyers matters, and we've tried as a system to deal with that by having legal resource centers and things like that. To the extent that you can get, an AI chatbot to be able to go through an interview and get all the information that has to go on the forms that get filed, that's a very good thing. That's the kind of access to justice that's very significant. It might be one of the problems, flip side of that, is that to the extent that it's creating information to people who are self-represented but have no ability to identify whether this is a strong advice or this is a weak advice, or what are the consequences of doing this. If you were going to send a
There's
nasty
no
letter,
discernment.
if you send a nasty letter to your landlord asking for a raise, or a decrease in your rent or something like that, is that going to cause your landlord to say, well, I don't want you as a tenant? There's a whole variety of things that you would get with a lawyer you wouldn't get. In a lot of ways, this is sort of the same problem that we had 30 years ago when things like the Novo Press would come up with,
Right.
make your own will or something like that.
Or the stationery shop.
Yeah.
Right.
I think Massimo's point, I had one thought, which was Massimo's point of certain law firms, I've heard this too, we've talked briefly about like using our own patent stuff as the market, or using an argument of good patent, all the sort of things we talked about earlier. I think a version of that where the larger firms will have their own data sets, but I think the smartest of the tools, or the biggest, Lexis and Westlaw, will eventually get agreement with them to use their data too, or some version of that. And it'll be kind of like group healthcare in my mind, where like when you're with a big large entity, estate, CalPERS or something, right? Like you get great healthcare because you have this huge negotiating pool. I think at some point, all these little boutique firms will get great patent AI tools because they've banded together in a sense to try to put together something, and maybe even relying on the big data.
Well, Thomson Reuters and Lexis, they are buying everyone up. So
Exactly.
That's just they've case text 650 million.
It'll get there eventually, right?
Yeah, they're buying.
And I'd be remiss if I didn't note that some people think what's going to happen here is that AI will, and all of the access to AI will be held by those that have more means, right? And that folks that need to access AI are going to get the sort of lesser version with not good answers, and that's going to be the folks that couldn't afford attorneys in the first place. And so we're still going to see that economic stigma, even within AI. Okay, so we've got a couple minutes here. I'd like to open this for questions. Do folks have questions of the panelists, things you'd like to hear?
I have one, and it just keeps coming back in my head over and over again. And when we talk about Google coming online and being able to access information there that we weren't able to access before. And when I did legal research, it was like, no, don't Google anything. Don't believe anything you hear or see on Google or Wikipedia, for God's sakes, any of these things. And the question that keeps coming back in my mind is it going to matter in 5 years? What we've experienced over the last 20 has been absolutely mind-boggling. Is this issue actually going to matter in 5 years? Are we going to skirt over this and get to a point of, no, we're just dealing with this and now we're going to deal with important issues? I see that it's important now for us to at least have some comprehension, but is it really going to matter in the long run?
No, let's just go. Let's call it a day.
But in all seriousness, I'll leave this to my panel, because does it matter? Are we going to move so quickly past AI, or is this going to fundamentally alter something about society and how we engage each other?
I don't have an answer to that question, but I think it's a great question, and particularly because Bard, Google's large language model, is integrated with their search engine, so eventually it's going to be indistinguishable. So the question of does it matter, like you can just ask Google, but you're getting a large language model response and the search engine response. The age of the blue links, right, the words and the links, that some people are thinking maybe that's going to come to an end. Probably not, but maybe we're not going to use blue links. It's just going to be large language models, and you're like, oh, perfect, that's the perfect answer. And if not, you click some of the words and that'll hyperlink you to the website. Maybe we're not even going to have a list of websites anymore. So it's a great question. I have no idea. But, the two things might completely be one and the same in 5 years.
Think about how weird that would feel to someone who wasn't your age, right? Someone's 65.
It's weird to me.
It should be weird to you, but no, I'm saying, like, think about Google, right? Like a giant screen of blue links, and think about the process you go through when those links pop up. You go, oh, that's from a random crazy right-wing website. Oh, that's from Wikipedia. That might be relevant. Oh, this is from IMDb. That's not what I want to see. Like you go through all this without even thinking about it because you're all sort of used to it and native to it. And what I'm saying to you, Massimo, is like that was a wild, weird process to get to over 20 years. And I think you're right. I think at some point it will be like, that's interesting. You're not even going to think about it. You're going to go through a different process that you've now learned.
Right.
That's exactly the same.
Will it improve to the point that you will treat your wall of text the same way you do the list of blue links?
Yeah, I think, or you're going to get there somewhere in your head.
Or maybe we love blue
Information
links,
literacy
and they don't go
shifts.
away.
Well, it's actually frightening to me if it were Google. I mean, because the first page is going to be all ad links. You know, this is where it's going to go. Where it's going to go to be
Purchase
It'll
influence.
solve your problem
Influence,
by
yeah.
buying this product.
Purchase influence, right?
Have you tried Bard?
No, I haven't.
It's free. If you have a Gmail, it's free.
I will try it. Yeah,
If you look, it's interesting if you use Bing, where you don't get the sources in ChatGPT, you get footnotes in Bing when you ask it a question in the chat. So it will actually let you link to something that is a closer to primary source, because still not primary, right? But we're getting a little closer. So I think you're right. I think information literacy is a moving target, and I think in 5 years this will look completely different.
yeah. We'll look back and go, why were we so upset?
However, for the next 5 years, we have to have some competence, right?
Well, I can give sort of an analogy though, because I mean, a dozen years ago, I did most of my research with books. Using Westlaw to do research was expensive, and it was
It's still
reserved.
expensive.
And it was reserved for certain types of things, and I did most of it just by pulling books out of the shelf and looking in the digests and things like that. And now I do absolutely everything electronic. And for me personally, it wasn't that difficult because I've always been an adopter of technology. For my colleagues, it's been horrific. The idea of having to not look at a book and instead look at what's on the screen, it has profound implications. And for people who are more and more invested in doing things the old way, I mean, the legal profession is profoundly conservative when it comes to the way it does work.
Absolutely.
And, which is why we're still doing things
And-
without billable hours.
And back to Jack's comment, where when he asked lawyers in the firm, they were saying, "I hope I can retire before that becomes a problem." Right? I mean, so these are people who are basing their retirement on the fact that technology is moving into their space, right?
Which ironically really is all about the fact that you have to learn something new. You're doing the same thing, you're just doing it in a different way. And there is this built-in inertia that prevents people
Resistance is futile.
from wanting to learn the new things that would make this work. I mean, I had a colleague since retired who, anytime there was a change, going from paper files to electronic files, that was just painful to him. And until I was able to set up a system by which he could essentially replicate his paper workflow on electronic documents, it was like, I'm just going to quit. I'm just going to print everything out and do it that way. But once he got used to it, then he was able to, it got to the point where it's like, well, I would never go back. And I have a feeling that that's what's really going to happen. Is that there's going to be this horrible, hand-wringing about how horrible it is to try to do these things. And then people will look back and say, that could never have been my attitude.
It's like all of those jokes that we all see, about the rotary phone and people who look at it and say, "What did you do with this? There's no buttons," right? Or pick your, it went around, folks. You
literally dialed.
You dialed, right? And it wasn't. Yeah. So I think you're right. I think change is happening faster. I think we have to react faster. I think for a profession that is as risk adverse as attorneys are, I think it's going to be hard. I think the lift's going to be hard. I worry a lot that technology is going to end run the lawyers.
Well, we're like the medieval people dealing with Gutenberg, right?
Right.
The central district has a rule still, I think a local rule that requires you to file like bluebacks and all that sort of stuff. And most of the judges I deal with, if you talk to their clerks, you send them in, you do all this stuff, and the clerks are like, "Please stop, we don't want these." And even though it's a local rule, do I comply with you? Do I comply with what the judge wants? And I don't know, it's very strange. They may have changed it recently, but at least it's 3 years ago. It's just like, they would get so frustrated with all this paper they get.
Yeah.
Because that's what we used to do, and that's what the rule says.
Yep.
So I'm gonna let you guys off the hot seat. Thank you very much. Appreciate it.